Thank you, Yolanda. You can go.
Great. Okay, thank you. Good morning, everyone. Thank you for being here on a Saturday. I know our Saturdays are precious, so I really appreciate you being here. My name, as Sandra said, my name is Yolanda Erickson. I'm a senior conservatorship attorney with Tzedek Legal Services. And Tzedek provides free legal services to residents of the County of Los Angeles. And we have a lot of areas. We do issues with housing and employment rights, and we have medical, legal partnerships. I'm going to miss half the group. We do guardianship work. We do some immigration work in the area of SIGIS, Special Immigrant Juvenile Status. We have lots of programs, but my program is conservatorship, and it's really the one that I know enough about to speak about. So I've been doing this for 25 years at Tzedek, and we love our community partners and always appreciate an opportunity to talk to families about what happens when your loved one is turning 18 or has turned 18, and how can we help that person live their best, most independent life. So when somebody turns 18, in the eyes of the law, they are an adult, and they are presumed to have capacity. So all of us, if I'm concerned about Sandra's capacity, for example, I have to prove that she doesn't have capacity to make adult decisions. Otherwise, according to the law, that you have all those rights, all your civil rights, all your personal rights, and you have the right to make all your own decisions. Now, with respect to our families, the issue becomes, what sort of capacity do they have? Are they minimally impacted by their disability, and can they make some decisions about their lives? We always want to promote decision-making and supported decision-making before we resort to conservatorships, because it is a process that is a court process. And it is, you involve the court and other agencies in your life once you go to conservatorship. Now, for a lot of our families, that is the choice, because their loved one is really so impacted by their disability that they lack the ability or the capacity to make decisions. But I'm going to start by talking about alternatives to conservatorship. There are things, I think probably everybody's familiar with something called a power of attorney. There are power of attorneys for healthcare, and they have various names, and there are powers of attorney for finances. So with respect to our population, the one that we're most familiar with, or what might be most applicable, is the power of attorney for healthcare. And what that does is it gives me the right to make medical decisions about Sandra. So Sandra signs a healthcare power of attorney, names me as her agent, and I am allowed to make healthcare decisions for Sandra. And there's a lower standard of capacity for a power of attorney for healthcare. It's enough to know that Sandra wants me to help her with my medical decisions. So if it's enough for your loved one to be able to say, my mom takes me to the doctor, my mom talks to the doctor, my mom helps me with my medication, and I want my mom to help me with medical decisions. Or they don't even have to say medical decisions. They say, I want my mom to help me with the doctor. It's enough capacity to allow somebody to create a power of attorney for healthcare, which would give me the right to go to Sandra's doctors and receive her medical information, accompany her to the doctor, make medical decisions for her. There's a power of attorney for finances. So if somebody has an estate to manage, that means they have property or assets or monies to manage, then they have capacity to sign a power of attorney for finances. In the state of California, I could make financial decisions for Sandra. So the difference between a power of attorney for healthcare and a power of attorney for finances is that I have to understand, I need a higher standard of capacity. I have to understand what would happen if Sandra gave me the right to make all those financial decisions, the risks, what a contract involves. Can she sign a contract for me? Can she invest my money? Can she, do other things that are generally require a sophisticated degree of capacity to understand a financial power of attorney and what the consequences to Sandra could be if I misuse a financial power of attorney. So again, with our population, it's rarely necessary. There are things like special needs trusts, there are able accounts, there are other ways to deal with monies that a person with an intellectual disability may have in order to shelter that money to prevent them from losing their public benefits. Now, with respect to public benefits, and I'm going to talk about SSI, you can become the representative payee. So that allows you to receive, I can receive Sandra's SSI payments, and then the check will come to Yolandi Erickson as representative payee. We shorten it to rep payee for Sandra. Okay, and that allows me to open a bank account, put the money in, and really manage her money. That is really what most of our families use, a rep payee. And that way they can manage their loved ones' SSI or SSD, depending on what kind of benefits they get. So that is in lieu of needing any kind of financial power of attorney. And financial issues become, as I said, there are other means. If somebody inherits money or gets money, that you can set up a special needs trust. You can also, there's something called an able account, which allows you to put money away in essentially a savings account and use that money for your loved one without risking loss of Medi-Cal or SSI. So that's mostly our population will not need a financial power of attorney. There's something called an education release. If your loved one is going to stay in school till 22, or even currently, once they're 18, they can sign something called an education release that allows you as their caregiver to access information, help them making decisions about education, to receive their IEPs and other documents that, again, at 18, it's my right. If I turn 18, it's my right to receive those papers, and I don't have to share them with you. So there's always issues about rights to privacy that are attached at the age of 18 as well, with respect to confidential records. There's also something called a medical authorization. Now, if you don't have a power of attorney for healthcare, it's a court procedure. If, let's say, for example, somebody needed a surgery, you can go into court, a one-time thing, and ask the court to give you permission to authorize the surgery. It's rarely used. It mostly becomes a little more complicating as people age and need different types of surgery. Also, you should be aware that the regional centers can make, under the Welfare and Institutions Code, can make medical decisions and can authorize something like that. Most of our families may not know that, and most of our families, in my experience, really do not want regional center to be making the medical decisions for their loved ones. So it's something to think about, but that's always sort of the, I think the legislature put that in there, in case there was nobody around to make decisions. So those are some types of alternatives to conservatorship. I would say the most commonly used is going to be something like the power of attorney for healthcare. And otherwise, if your loved one lacks capacity to execute a power of attorney, has much more complicated medical issues, and I'll talk about the other powers, then there's something called a conservatorship. Now, there are all kinds of conservatorships. It's confusing. There are 3 types of conservatorships that are heard in the probate court, and those are a general conservatorship. For example, somebody is in a car accident and they are in a coma, they lack capacity for a certain period of time. And you can go into court and get a conservatorship so that you can make decisions for them during that period. And when they may always need a general conservatorship going forward, or that may be available for a short period of time and may not need to be renewed. There's a conservatorship for people with neurocognitive disorders. It's a big word that they've changed. Used to be Alzheimer's dementia, and we still refer to that in practice because it makes the most sense to people. So if somebody lacks capacity because of Alzheimer's dementia, you can, in the probate court, you can get a conservatorship for that gives you the power to administer psychotropic medications, which are very special medications used for the treatment of Alzheimer's and dementia, and also the ability to place somebody in a locked facility if that is what they need. So that's another type of a conservatorship. And we're going to talk about limited conservatorships in the probate court, but I'll touch on one other conservatorship that's really confusing. A mental health conservatorship. So if you need a conservatorship for somebody whose primary diagnosis, and I mean primary diagnosis, is mental health, and they have schizophrenia or bipolar or something, you would need it's called an LPS conservatorship, and that's because of the act that created it, and that is heard in the mental health court. And those conservatorships are obtained by the public guardian through county council. And it's very confusing to our families because your son or daughter may have a comorbidity, or they may have autism with mental health issues as well. But they would still, what would be best for them would be a limited conservatorship in the probate court. However, if it's someone that gets 5150'd or has extreme mental illness where they're placed in a psychiatric facility, your limited conservatorship will not work there for allowing you to have access and to somebody that's in a locked mental health facility. For that, you would need an LPS conservatorship. It's a very different ball of wax. And if anybody needs more information on that, I'm happy to provide it. Sandra can let you know how to get in touch with me. It is not something that Tzedek does, but we do have some very good information on those that concerned about somebody with a straight, again, the mental illness is their primary diagnosis. Okay. So what we're here to talk today about is something called a limited conservatorship. And again, the title is probably not the best because a lot of our families say, no, I don't want a limited conservatorship. I want the whole conservatorship, because it doesn't, the title is just refers to you're given the powers over your loved one that they cannot exercise themselves. So the idea of the court is not to take away everybody's right to everything, but to look at what powers you need to help your loved one. So a limited conservatorship is for somebody with an intellectual and developmental disability. And in California, the standard is that occurred before the age of 18. And it is ongoing. It will be a disability that they will have for life. So that's what a limited conservatorship for. And I think what's unique about limited conservatorships is that you can apply. In other words, Sandra's going to apply for a limited conservatorship for me. And the limited conservatorship was really designed by the legislator to try to promote independence, not take away powers that I can enact. So there are 7 possible powers under a limited conservatorship. So the court is making an order giving Sandra the right to have these powers over me. And we're going to talk about the powers. The first one is medical powers. So I have autism, but I also have a seizure disorder, and I have a very complicated medical issues. So Sandra would need the right to make those decisions, and I am not really capable of understanding what kind of medical help I need, and or I have issues, taking appreciating what kinds of prescriptions I need, and so she would have the right to make the medical decisions for me if she got the medical powers, and that includes the right to accept medical treatment. Sandra decides I need this surgery, or she decides I don't need the surgery and that it's not anything that's going to help me, or she doesn't want to put me through another procedure that is not likely to result in any great benefit for me, then she has the right to decline medical treatment as well. Okay, so while a conservator has to act in the best interests of someone, you get to make those decisions that you've been making until they were 18. Yes, I want them to do this, or yes, or no, I don't want this medical treatment. So it allows you to make the same decisions you would make for yourself. It's placing you in that ability to communicate with doctors, to receive all of the information, and then in order to, and the other thing about it is you can send and receive medical records. So if I refer to a new doctor and I don't want to have all those tests again I just had at the other doctor, I can say to the first doctor, please send all those test results to the second doctor so that I don't have to put my loved one through repetitive tests.
I'm going to share this pretty fast so you can.
Okay. Yeah, perfect. Okay. So I'll just finish with medical. It's a little out of order, but that's great. So that's what medical powers are. Again, the right to accept or decline medical treatment for your loved one. Now, we're going to go to power number 1 on the screen so you can see this: to fix the conservatee's residence or dwelling, which is kind of legalese for, or I don't even know. It's a little crazy writing, but that's what it says. To decide where your loved one is going to live. Now, we know most of our young adults remain at home, but there are all sorts of other housing options. And so it may be, if your loved one is minimally impacted by their disability, and they may be able to just keep this power. They can decide where they're going to live, or have input, or make those sorts of decisions. Oftentimes, this is a power that intellectually disabled people with conservatorships will retain this power to decide where they're going to live. Because as I said, most adults remain with the family, but there are all sorts of things available in terms of living. And if that's something that interests you, or something that interests your loved one, it's a good time to work with the regional center and say, hey, what's out there in terms of supported living, sharing an apartment, if you have a loved one that's going to go on to college. These are things you can look into and either you would say they can't really make those decisions, and I need to have that power to decide where they live, or it's it's a power that they can have. Now, number 2 is a really, really great power to have, and I usually recommend that most conservators advocate for this. It's access to the conservatee's confidential records or papers. So as I said before, they're 18. You can't see their confidential records and papers unless you have court authority or your loved one has the capacity to give you a release to see their records and papers. So I always say that I always use the example of when my son went to college. My son is neurotypical. He goes off to Berkeley, and they send us a bill for his tuition, but we can't open and access his account in order to pay the bill because he's an adult, he's 18. So he has to give us permission to access that information in order to pay his tuition. So neurotypical or someone with an intellectual disability, it's the same. 18, they have the power and the authority. So confidential records and papers, as we know, is a really important power to have because everything today involves some sort of record, paper, access, password, so that's an important power. I'm going to go a little out of order here. I'm going to go to number 7, the decisions about education. Again, this is something sometimes that if somebody's minimally impacted by their disability, they can make those decisions about education. Primarily at this point would be, do I want to stay in school till 22? Do I want to go after that, or in lieu of that, do I want to go into a job training program? What do I want to do in terms of education? So that is the right to make decisions about education. And again, you will be able to receive education records and papers. And I think we spoke about if you didn't have a conservatorship and your loved one had the ability to sign an educational release, that would give you the same access. This is included in the limited conservatorships. And let's see, we've done the confidential records. So there's a really, excuse me, we're gonna, where is it? The right to contract. I'm missing it on here. Do you see it? Oh, number 4. Okay, so you're saying what is this? Enter into contracts on behalf of the conservatee. Now, there are conservatorships for over the person, which is likely the conservatorship that you want. It allows you to make all those decisions about the person's care, custody, and control. Again, these are legal terms, but they basically mean what they would mean as a non-legal term. Means you get to make decisions about where the person's going to live and what they're going to eat and where they're going to school. And so there are all these other issues. But in a conservatorship of the estate, if you have a large amount of property, I think we're all familiar with that from the Britney Spears case. So she had a lot of money and a lot of ability to earn money, and her father also needed a conservatorship of her estate in order to manage her money, invest her money, and deal with all that. Most of us don't have those issues, and especially with this population. So the legislature knew that most people with intellectual and developmental disabilities would receive their source of income. The primary source of income would be government benefits, and the rep payee ability is there to manage that money. So you don't need a conservatorship of the estate to manage government benefits. But what happens when you want to sign up for a cell phone, or you want to, now with self-determination, you want to contract with outside vendors? I mean, I'm getting that's a little specific, but if you want, I'm just going to use the cell phone. My son needs a cell phone. I want to get him a cell phone in his name, and I want to be able to contract with whatever the cell phone provider is to get him a cell phone. So again, without this ability to contract, which is unique to limited conservatorships of the person, you wouldn't be able to do that. You would have to go to court and get a conservatorship of the estate in order to contract on their behalf. So this is a very good thing about what the legislature envisioned for this population by creating that right that gives Sandra the ability to make contracts on my behalf. Let's say, for example, your loved one has the right to make choices about residence and is very excited because he's going to go into an apartment and have in supported living. Well, somebody needs to be able to sign the lease on that apartment, right? To sign the contract. This power gives you the right to, again, help your loved one stay as independent as possible by allowing you to enter into contracts on their behalf without having to have a conservatorship of the estate. The other thing that's very helpful, and I hope it never happens to you, don't have to, and that you don't experience this, is it's, I don't know if it's as bad, but when about 5 to 10 years ago, there was the whole issue of identity theft that we would find this population was really was easy to steal their identity. You had a group of people that were over 18 that had a monthly income. They had SSI coming in every month. They had a regular monthly income. They had a social security number, and scammers were able to steal their identity. And we had one young man that didn't have a driver's license, but had bought 2 cars. Somebody had bought 2 cars, and the parents didn't find out until somebody came to repossess the cars because the payments weren't being made, and they had no idea what they were talking about. And of course, the cars were not at his address, so it was the scammers were able to, the cars were not at the address on the young man's all his paperwork, but they had managed to use all of his information to buy 2 cars. So I've always thought, and that's the extreme, but also it used to be, we used to have a lot of people that were signed up for cell phone contracts. They'd go to the mall with their friends, and they're, everybody needs a cell phone, and it would turn out that the person with the intellectual disability had, bought everybody a cell phone in a contract. It was just like, so the beauty of having this, if and I mean this, not saying there's a beauty to that, but if you have the right to control, if Sandra has the right to control my ability to contract, and somebody steals my identity or buys something in my name that I didn't clearly buy, all Sandra has to do is just show them this and show them my letters of conservatorship, what clearly shows that she has the right to enter into a contract on my behalf, that I do not have the right to contract. The contract becomes null and void on its face. So she doesn't have to go through that hassle. I don't know if any of you have ever had something charged on your Visa card that you didn't charge, and just the amount of time you spend trying to clear up these things. But this says he never had the ability to contract for that. So even if I try to buy something, if I sign up for something, Sandra can say it has to be voided because he didn't have the legal right to buy that or to enter into that contract to purchase the cell phone. So that's it sounds a little more complicated than it is, but it's an unusual power to have in a conservatorship of the person. That is usually something, if I'm trying to conserve my husband, for example, and I want to make any decisions about anything he buys or sells, I have to get a conservatorship of the estate. in order to manage his money and to make those sorts of decisions. So I know it is sort of a long explanation, but it's a very unique power, and it's a very important power, hopefully just preventive power. The other two powers, I think we're down to two, are very controversial. They talk about really limiting somebody's civil rights. And it's not anything we want to do if it isn't absolutely necessary. One is the right to control your loved one's right to marry or enter into a, I think they still have the language of a domestic partner agreement, because I think there's still some state language about that. So basically, it gives you the right to prevent your son or daughter from marrying, or if they do marry, it allows you to undo it. Now, I think most everyone feels there's nothing they would want more than their son or daughter to find a person that they want to spend their life with, and they'd be delighted if they were able to marry. That being said, as we know, there are again some people out there that find that your son or daughter has a monthly income, and decide that that's that would be a great way to have that money coming in. And it doesn't happen often, but it happens enough where it's cause for concern if you think you have a person that's very vulnerable, or it's been also unfortunately with with people coming and going, again, people have found out that their loved one has married somebody and that person is nowhere to be found. Again, this is really more for people that are minimally impacted in their lives, and it's a rare occurrence, but it does occur. So again, you may or may not need the right to control their ability to marry, and generally, I don't think most families do need that right. So that's a power that you can leave with your loved one, and that they can decide whether they want to marry or not. And then the most controversial is and probably the most impossible to enforce is the right to control somebody's social and sexual contacts and relationships. Again, I think what the legislature was looking at is the vulnerability of this population, and how they're easily taken advantage of. And on the bad news department, the statistics for sexual abuse for both female and male persons with intellectual disabilities is staggeringly high. Something like 75% of women, and the men is getting closer and closer all the time in that number. So it is something to be concerned about. Some of this comes from you have loving, wonderful, embracing. I'm thinking about people with Down syndrome who, all my families with loved ones with Down syndrome, the most loving, hugging, wonderful. I always look forward to getting those hugs, and that was the biggest problem with COVID, is I didn't get all my hugs from families. And so you have people that may present as being so affectionate and outgoing, and that's part of their personality. And again, unfortunately, some of you may have had issues where there has been some incidences of sexual abuse or somebody taking advantage of your loved one. So that's a very personal decision to make. It's not something that the court is really going to be in favor of granting. Regional centers are rarely ever support the right to families having the power to control the right to marriage or the right to control social and sexual contacts and relationships. But it is something that if there are some really good reasons for you needing that, there's a part of the petition that's called a confidential supplement, which is a confidential document. It's not a public record, where you can tell the court why this is of concern to you. It may involve sexual abuse in the past. It may involve certain vulnerabilities, but otherwise, you know, most courts and most of the idea is to allow people to retain those powers, those basic fundamental civil rights. But again, every case is unique, and you really have the most information and the best sense of what your loved one is capable of what powers they're capable of exercising and what powers that they aren't. And finally, it's not a power, but the court will ask whether or not the conservatee's right to vote will be taken away. It used to be routine that it was a wholesale revocation of the right to vote for people that were under limited conservatorships. The idea was that the court, that there was just this basic misconception that you didn't have capacity to understand, you'd have to go and register, you'd have to vote. But we know that if somebody can express an interest in voting, they certainly have retain their right to vote. And the state disability, DDS, Department of Disability Services, has a wonderful website. And part of that is how can someone with a disability vote, which really applies across the board, not just to someone with an intellectual disability, but there are all sorts of ways for them to vote. You know, absentee, they can make an X, they can have two people come and help them fill out the sections, or one or two people. They can certainly, you know, drop off a ballot from the window of the car. Somebody can drive them there. They could drop off a ballot. If you're interested in ways that people can vote, it's a wonderful website, very, very inclusive of a myriad of ways. If you want to vote, there's a way for you to vote. So it's an important right, and it's something that isn't just taken away, wholesale revocation of the right to vote anymore. The courts have become much more sensitive as to really making this a document that's going to work and allow people to participate fully. So that is, a couple of things. Those are the 7 powers, and the 8th with the right to vote, that are involved in a limited conservatorship, and really probably more information than you need because it's a lot to take in. But it does speak to the uniqueness of this thing called a limited conservatorship, and just how much help it can give a family in making sure that their loved one lives their best, most independent life with as much help as they need available. Again, it's a court process. You fill out a petition. You go to court. Every proposed conservatee, you are the conservator. Anybody can be a conservator if they're over 18, it can be a family member or a friend. There are people called professional conservators. It's probably not something that you're going to need, but that exists as well. If you go to court, you fill out a petition. We have a wonderful conservatorship clinic that will assist you with filling out all the paperwork. You need a doctor's report. It's something called a capacity declaration. It needs to be completed by a doctor or healthcare provider or a psychologist that says that your loved one lacks the capacity to make informed decisions about their medical care. And that allows you to then get the medical powers, the medical power, one of the 7 powers. The court relies on that signed declaration by a healthcare provider to tell the court that you lack that ability to make those medical decisions. The other thing that's required in order to have a limited conservatorship is membership in a regional center. we have, we have a lot of experience with people with intellectual and developmental disabilities that never belong to a regional center. These are people that are going to be probably in their 70s, late 60s. I mean, 65, 70 years ago, families were told to institutionalize their loved ones. And if they took them home, it was sort of, you're on your own. So I think families were very leery, even when regional centers were created in, I believe it was 1967, people were just very nervous about getting involved with any sort of organized system that would tell them what to do with their loved ones. So while in my lifetime, regional centers, are here and fully functioning, the court requires a report from the regional center with their recommendations about the powers. Regional center will generally schedule a meeting with the families and provide a report to the court. And as I said, regional centers will rarely ever recommend that Sandra have the right to control my social sexual context or control my right to marriage. And of course, that can be overcome. Their recommendations are guidance to the court. They are not the last word. And every proposed conservatee in California gets an attorney, their own attorney. So gone are the days when I went to court and said, I need to conserve my son. And they said, okay, fine. Conserve your son. He'll just be conserved for life. And oh, he's nonverbal. Well, he can't say anything. He can't make a comment. So the court realizes that person needed a voice. And oftentimes our loved ones may not be verbal. They may not be have the ability to communicate with their lawyer, but they still get a lawyer appointed who is going to look and make sure that the powers that I want, or even the underlying need for conservatorship, is appropriate and necessary. And they are going to make a report to the court. So there are protections in place for, I think, everyone. The probate investigators department will make an investigation of whether or not you are appropriate to be the conservator. And basically they run a CLETS check to make sure that you are, don't have any convictions. Oftentimes things will come up that are, it would be rare that even if you had some sort of conviction in the past, that you would be denied a conservatorship. They're just looking at obvious, issues of abuse in the past, some sort of abuse or other criminal actions. And in the issue of conservatorships of the estate, I think it's much more important because they're looking at people that may have, committed fraud or economic issues. But again, most of our clients, most of our consumers are not seeking a conservatorship of the estate. So the different issues, but they will run a check. Also, the court doesn't care if you're documented or not, or if your child's documented. And so we have families where their children may have been born here, and they're able to, and they themselves are not documented, and they're able to get conservatorships. I think that the thought is in the court that now you have a person who's 18 years old. It's really important, if they don't have capacity to make their own decisions, that we have somebody that can make those decisions for them. So I think it's very empowering for families, especially where documentation is an issue, to get a limited conservatorship, because it gives them not only the authority, but it gives them the sort of a mandate from the courts. You have to act in the best interest of your conservatee. So you go out and find, every service, every program, everything you can find. And I find that it for a lot of my clients, it's very empowering when they become conservators. They have not only their love as a mother, that they would of course take care of this person, but they have an obligation, they have a duty and a legal right to make decisions and to ensure that that person lives their best life. So I think that's a very important power for people in the county of Los Angeles. We have a lot of people where documentation is an issue, and at least it's not an issue with respect to conservatorships, whether you can be a conservatorship or whether you can be conserved. With that, I think I'm gonna stop and see if there's some questions. Again, I think Sandra's put up the information on our conservatorship clinic. The conservatorship clinic helps you with all the paperwork and helps you file for conservatorship. The thing that our clinic does, it's a self-help. We do not represent you in court. So you will have a hearing. We do not accompany you to the hearing. Now, that's where my job at Tzedek comes in. I'm an attorney. There are two of us that do direct representation, and we really take very challenging cases where there may be a disagreement among families about who should be the conservator, where there's been some other issues that are complicated. And we take those cases for direct representation. The clinic will also refer to us on cases that people come through the clinic and they say, I think this person really needs some direct representation. But otherwise, we simply couldn't help everybody if we were being direct rep on every case. We've been doing, I think we opened the first clinic in 2007. So we've been doing this a long time. We've pretty much got this down to a science. Actually, we have it down to an art. And it's a very simple process. I know it's intimidating for people. Oh, I don't want to go to a hearing. I don't, if I can go to court without by myself, you can. And especially now with all the virtual court appearances, you get to sit in your house and, just participate, or you can be on the phone and participate in that court hearing. And our goal is always to have everything in case and sort of buttoned up so that there really aren't any issues at the hearing. And the clinic's number and email is their email address. We are overwhelmed with calls. It may take probably 10 days before you get a call back. And again, if you're going like 2 weeks and nobody has returned your call, please, you can reach out to me or reach out to Sandra. She would be happy to send me an email, I'm sure, to let us know that somebody's having trouble. But you have to have some patience initially. So I'm happy to take questions from people, and it's I will tell you, I think more of the general questions are better. It's hard for me to to really give you information on a unique to you and to your situation without me having a lot of the facts, and it may not be as helpful to other people.
I'm going to stop the recording so you feel comfortable asking your questions.
Okay.
Thank you.